Well, there you have it. All 12 jurors voted unanimously to recommend the death penalty. Let's get a reaction right now from Law and Crime trial analyst Misty Marris. Misty, it's great to see you.
Thanks for having me, Jesse.
Are you surprised by this?
I actually am not. We've been covering this case, obviously, here at Law and Crime, gavel to gavel. And I will say that I thought the prosecutors did such an excellent job of setting forth the brutality of these killings as aggravating factors. As we know, that's what this comes down to, right? Aggravating factors being outweighed by mitigating factors. Where is it in the balance test that the jury's going to make a decision when contemplating the death penalty? Well, Jesse, I have to say, watching that testimony, hearing about those brutal killings, I was sold from an aggravating factor perspective. And the medical evidence that the defense set forth, you know, they used expert testimony, relied heavily on that. That's what they had to do, but it just was not compelling in the face of what had happened to these women.
The prosecution had to get this. They got it one time. They got the death penalty recommended a first instance. Prosecutor Joe Dieters made that inappropriate comment. They had to do a second try. So it was really a lot of pressure for them to get this done a second time. But my question is, the defense missed opportunities. You know, Kirkland presented an unsworn statement to the jury. I'm curious what you thought of that. And then the second point, they brought out Dr. Wu, who said that this guy suffered from a mental disease or defect, but his credibility was really put into question by the prosecution's witnesses and the prosecution's statements. So did they not do themselves any favors here?
Well, first, I think the unsworn statement, I was sitting in your chair, Jesse, when that was being broadcast live, and it was very similar to what Kirkland had said in his prior trial. He also did an unsworn statement during the sentencing phase of his original trial. But he's sitting, you know, reading it off a sheet of paper. There didn't appear to be any true emotion to it. I think he did himself a favor by saying, hey, look, I'm not looking for you to exonerate me. You know, I'm not looking I'm not looking for you to forgive me. And I understand if you will kill me. This is what he said. I understand if you kill me, but I ask you to spare my life. I did not feel emotion behind that. Like I said, just reading off a sheet of paper, I did not find that to be too influential. But you're right, Jesse. This is always a problem with experts in trial. Dr. Wu.
Right.
He was able to be raked over the coals because he's testified so many times. There's so much fodder out there that you can use in order to impeach his credibility. And so that's why he was not the best expert. But, Jesse, I don't know if there's any expert on the planet that was going to be able to give the defendant a shot here. And one of the reasons is that some of the more compelling testimony related to this horrific abuse that Kirkland suffered as a kid, which is obviously terrible, but most of that was based on Kirkland's own account, as opposed to contemporaneous medical records or ACS or child services or anything at the time. So you don't have a great case as a defendant here.
Yeah, especially when he killed 5 women in his lifetime, and including 2 young girls, Esme Kenny and Cassandra Crawford, 2 beautiful young 13 and 14 years old. It's horrific. Misty, thank you for your insight on that case. And if there's an update in the Kirkland case, we'll let you know, because the judge will actually be the one who imposes the sentence, and I'm sure we'll be broadcasting that here on Law and Crime, but we'll update you as always. But here on Law and Crime, you know that's not the only thing that we cover. There are always a lot of stories in the news, and we want to bring that to you right now. So here is a special report about some other news happening right now.
Here are today's top crime stories trending on lawandcrime.com and across the country. Authorities in Castle County, Delaware, are hoping a DNA rendering of a woman whose body was found 41 years ago will help to shed new light on the cold case. Investigators generated the image using DNA from the victim, whose body was found nude in a drainage ditch in June of 1977. Authorities also reconstructed the victim's face in 1998 and released this photo of what this Jane Doe might have looked like. A video of a violent incident at a nail salon in New York City is raising some eyebrows. The crazy melee reportedly started at New Red Apple Nails in Brooklyn when a customer refused to pay after she accused a worker of messing up her eyebrow. Customer Christina Thomas and nail salon employee Hui Yu Zhang were both arrested and have been released from police custody. NASCAR CEO and chairman Brian France was arrested in New York for reportedly driving under the influence and drug possession. Police pulled over France in Sag Harbor Village when they noticed he was driving erratically. France was allegedly intoxicated, and when investigators searched his vehicle, they found oxycodone. That's when France reportedly name-dropped his associations with President Donald Trump to no avail. France faces charges of aggravated driving while intoxicated and criminal possession of a controlled substance. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Great stories, Anthony. You can go to lawandcrime.com to learn a little bit more about them. And I have to say, I don't know exactly the details of that nail salon, but if I was in my hairdresser and, you know, he messed up one strand of hair, I'd probably do the same thing. Misty, I don't know if you would have done the same thing.
Gosh, well, I just got a manicure, but
and,
I mean...
And they look fantastic. But I want to talk about a different case. I want to talk about the NASCAR CEO. How many times in your life have you name-dropped Donald Trump to get out of trouble?
You know, I actually haven't yet, but I think I'm going to start. Why the heck not? Go straight to the top, right? And that's what it looked like we had here. Unfortunately, it sounds like the Suffolk County cops didn't really put too much credence on that.
Yeah, that's true. That's a good point. Now, what kind of trouble is he getting into here in the sense that in terms of what will happen to him as being the head of NASCAR if they examine the facts and they determine that he is ultimately guilty of this? Yeah,
well, he could be asked right now. The reports from this morning indicate that he actually has already stepped down and taken a leave of absence for an indeterminate amount of time. That's while NASCAR will actually look into what happened. Look, we've seen this before. When something's bad for business, private corporations can say, hey, look, your reputation's not doing us any favors from a financial perspective. So he could be asked to step down. You know, they could wait for the heat to be taken off where they investigate. Of course, he hasn't been convicted of anything yet.
Right.
So there will likely be an investigation period, but he could just find himself without his position.
But how bad is it, if you think about this, is it so bad that it was the DWI, or was it the idea that he's name-dropping Trump to get out of trouble?
Well, that's a PR nightmare. So you've got the DWI, you've got criminal possession of a controlled substance, which is also obviously problems from a legal perspective. But to have somebody in the public reportedly name-dropping Donald Trump in order to get out a get out of jail free card, well, that doesn't look too good from a business perspective. So from public relations, maybe not the best move.
What's the only way that he'd be able to keep his job, and put this behind him?
Well, look, it depends on what we're reading now, what we have in the reports, right? But we don't know exactly what happened on that night. NASCAR is going to do an investigation. We'll see what happens from the criminal perspective if they enter into some sort of plea deal or something like that, and maybe then it could all be washed away. But a lot of this is just weathering a PR nightmare.
Right. And I wonder how much it is, you know, I always see Tiger Woods, right? The Tiger Woods example. I hated to see him like that, but he's back on top right now. So who knows? This guy's not one of the drivers. He's one of the corporate. He's the head of he's the image of it.
People come back in time and in some circumstances.
Yeah. All right. Well, we'll let you know if there's any updates on that. But again, go to lawandcrime.com to learn a little bit more about the top trending stories. We're going to take a quick break on our end. And when we come back, we have a very big case to talk to you about. Stay tuned. Okay, so that was the prosecution's opening statement in the Stephen Foster case out of Georgia. This is, again, this DWI case. But are you surprised that it's at trial? I think I am. But, Misty, are you surprised? Because usually, don't these cases get pleaded out? I mean, do you really see these kinds of trials?
No, I really would have thought that this type of case would be pleaded out, especially since, you had this blood test, which is obviously a controversial issue, but it was very clearly putting Foster over the legal limit for driving. So yeah. I'm a little shocked that they didn't try to work this one out before getting into the courtroom.
Okay, so let's try to understand this. And we're going to play you the defense's opening statement. He wanted a blood test that night. So forget the roadside sobriety test, the field sobriety test. I want a blood test right that night. But the problem was he got the blood test, but it was sent off to a crime lab, and the results didn't come back that night, right? Am I understanding that correctly?
Yeah, and so his argument is that because of the time period between giving the blood and going to the lab and all that, that the test is not credible. And that's essentially what the defense is trying to argue. And that under Georgia law, you do get this independent blood test so that he was deprived of a statutory right. And you saw the common theme for the defense, which we'll hear when we hear the opening statements, is, well, this is an overzealous prosecution. This was the police went too far because he didn't get that independent blood test. He didn't have that blood test that night. But I got to say, Jesse, of course, those are all facts you're going to present at trial to undercut the credibility of what the prosecution has. But once you do have a test putting you so far over the legal limit, not really in a close call, it's going to be tough to use that as your primary defense at trial.
You know, I'm curious about the validity of these blood tests, and we'll talk about that in a minute. I think now that since you've heard the prosecution's opening statement, let's try to understand what the defense is going to argue. So here's the defense's opening statement. Take a look. Okay, so this is different than regular DUI cases. A lot at stake, very interesting defendant, and you just heard the defense's argument. Let's bring back on Misty Marris and talk a little bit more about it. I'm confused. Are blood tests more accurate than field sobriety tests?
Well, field sobriety tests are a little bit different, right? Because you're watching the way somebody is interacting. You'll see, like, doing the alphabet backwards. You'll see visual cues as to whether or not somebody is looks or appears to be intoxicated. But the blood test is going to give you those levels. It's going to give you that number that would be used in a court of law to say where where somebody fell on that scale and were they over the legal limit. What we saw the defense doing here is trying to undercut the validity of that blood test based on what's really a chain of custody argument, right? Because they're saying it was taken that night, went to a lab, sat on for X amount of time. By the time we got the results, it's so much later that there's the possibility that this is not accurate. And that's what the defense is
that a fair
on.
argument?
It's what you do, especially with any sort of expert testing. You're always going to try and undercut the credibility or validity of that test.
But I mean, maybe it makes sense. If you have blood, wouldn't it be more accurate if you could show what the results are that night as opposed to months later?
Well, and I think that's the other thing is that you also have this unique issue in Georgia where you do have a statutory right to this independent test. And we have the defense, what we saw, laying forth an argument saying, well, look, the police said they would accommodate him that night, but then they ended up sending this blood sample out to another facility. You never told them. So it's kind of undercutting the credibility on the whole.
Well, let's see if it works, because when we come back, we're going to analyze more of this case. And you know where we're going to start off? We're going to start off with Justin Smith from the Dalton Police Department. He was one of the officers that pulled over the defendant, and he's going to explain to you what happened that night, including what Mr. Foster said. So stay tuned. We're covering a lot more here on Law and Crime. It's funny, as we listen to this case, we can't help but think about perhaps the political aspect of it, and I want to talk about with Misty Marris a little bit more about it. We have a Democratic congressional candidate. According to what we read about in this case, he said that as soon as the officers knew who he was and they reported it in, they're like, bring him down to the station, don't give him the blood test, there was a bias because he was a Democratic congressional candidate. Do you think there's any truth to that?
Look, I mean, it's not a bad argument, right, that he's not being treated fairly under the law because he's a public figure. He's somebody that is known in the community. And look, I think that he's doing, from a defense perspective, everything he needs to do. That all feeds in with his argument, right, Jesse? That he was denied that statutory right to have another independent test done. That he was treated basically unfairly by overzealous police officers. Than anybody else, the situation would have been different. So that's all feeding in to his underlying argument from a defense perspective.
We talk about reasonable doubt, and he's throwing what I believe is doubt. But is it reasonable? The idea that maybe he had this condition from the malaria, he needed to drink, he has ADHD, he's got a weird personality. Is this reasonable doubt to say that he actually wasn't intoxicated while driving?
Look, I think that really the ADHD, malaria, those factors, maybe they're clouding the pool a little bit, and that's what their purpose is. But to me, that's a complete red herring. And if I'm the prosecutor, I'm going to say there's no reason why the malaria and ADHD factors should go into your deliberation because, look, we have a blood test that says the BAC was over the legal limit. And that's where I would redraw the focus.
And then they keep saying that blood test, though, was months after it was tested, and maybe those fermentation, it raised the level of the blood alcohol content, and maybe that's something they have to consider. But Misty, when we come back from our break, you know what we're going to talk about? We are going to talk about the fact that the officers didn't smell alcohol on him. He wasn't swerving from lane to lane. And I'm going to ask Misty whether or not that's really an indication of a driver not being intoxicated or not, because you know that the defense is harping on those facts. So when we come back, we're going to play you a little bit more of the testimony of Justin Smith from the Dalton Police Department, and we're going to continue playing this case for you. And a little bit later on, we'll let you know what the verdict is. So stay tuned. We'll be right back. Well, we knew this. We knew this was going to happen. We knew the defense was going to cross-examine Justin Smith, the arresting officer, and they had some pretty interesting questions for him. Let's see how he did. I want to talk again with Misty Marris about it. Okay, let's break it down. If someone doesn't smell of alcohol and they're not driving erratically, if I'm sitting on that jury, I'm thinking, maybe this guy wasn't intoxicated.
Yeah, that's why the focus for the defense case is that, Jesse, because they do have these, the field sobriety tests that you'd see any police officer do when somebody gets pulled over. Those are observations that will generally lead you to believe that somebody was intoxicated. So one of the primary factors was there the smell of alcohol, swerving on the road. And the fact that the defense can focus in on that adds extra credence to their argument that, hey, look, this blood test might be faulty and maybe he wasn't intoxicated at all.
Right, because what's more important, what the blood alcohol content actually says or what are the signs? So if somebody has a better tolerance for alcohol, I mean, is there an argument to be made, well, maybe he has a stronger tolerance, maybe he didn't drink that much, yes, he had alcohol in the system, but if he's not exhibiting any dangerous signs, I mean, really the issue there was the, what was it, the headlights weren't on, that's why they saw something was a little strange. You see what I'm saying?
Oh, absolutely, Jesse. And it's funny that the way you couch that question is perfect because that's what the jury is going to be asked to weigh. The jury is being presented with all of these factors. And the question is, does the jury believe that he was intoxicated at this time? The defense obviously presenting factors, and they do have some decent arguments here because some of those objective tests, some of that sensory information that comes at the field sobriety test swung in their favor. But it's the jury who's going to decide. There is no balance of what's more or less important in making that decision. It's what the jury chooses to believe, and did the prosecution prove their case beyond a reasonable doubt.
Now, on the other hand, do you think that the jury is only going to be so patient and they hear things like, this guy's got a quirky personality and this guy's got ADHD? I'm sure a lot of people have ADD or ADHD, quirky personalities. Is that really, we're going to say that that is what is exhibiting strange behavior? Is that a fair argument?
Yeah, look, it's what the defense has to work with. That, look, this guy might not act like you or I would anticipate somebody would act under these circumstances. The reason that his behavior is more erratic than your average Joe is because he has these underlying medical conditions that are going to tend to make somebody think that he is intoxicated when he's absolutely not. To me, in this case, and I understand there are arguments about the veracity of that blood test, but as a juror, when you have that cold, hard, scientific evidence, unless the defense can really undercut it with a chain of custody argument, it's tough to get over.
Do you think it was unfair to him, though, that they said, hey, listen, we'll take you to get the blood test, but really all they did was get his blood drawn that night, but it wasn't tested that night? Is that fair to him?
So, I'm not sure that there would be a fairness argument in other states, but I will say, given the statutory scheme in Georgia and the fact that the argument from the defense perspective is he was actually deprived of a statutory right to get that
such like a lawyer.
Yeah,
like
I can't help myself. But all of those factors really feed into what you're talking about, Jesse, which is the overriding theme that he was not treated fairly, and that there's enough reasonable doubt here to show that he was not necessarily intoxicated.
Well, we're going to have to see. There's a lot more to talk about in this case, and we're going to recap it when we come back. So stay tuned. This is just the beginning part of the Stephen Foster case out of Georgia. We'll be right back right after this. Welcome back, everybody. So before we talk about our other case that we're focusing on, the Stephen Foster case, there's always so many developments in the news, so many stories. They're always constantly trending. So we have a special report about what stories are happening right now. Take a look.
Here are today's top crime stories trending on Law&Crime.com and across the country. Authorities in Castle County, Delaware, are hoping a DNA rendering of a woman whose body was found 41 years ago will help to shed new light on the cold case. Investigators generated the image using DNA from the victim, whose body was found nude in a drainage ditch in June of 1977. Authorities also reconstructed the victim's face in 1998 and released this photo of what this Jane Doe might have looked like. A video of a violent incident at a nail salon in New York City is raising some eyebrows. The crazy melee reportedly started at New Red Apple Nails in Brooklyn when a customer refused to pay after she accused a worker of messing up her eyebrow. Customer Christina Thomas and nail salon employee Yu Zhang were both arrested and have been released for police custody. NASCAR CEO and chairman Brian France was arrested in New York for reportedly driving under the influence and drug possession. Police pulled over France in Sag Harbor Village when they noticed he was driving erratically. France was allegedly intoxicated, and when investigators searched his vehicle, they found oxycodone. That's when France reportedly name-dropped his associations with President Donald Trump to no avail. France faces charges of aggravated driving while intoxicated and criminal possession of a controlled substance. Those were today's top crime stories. I'm Anthony Velez for Law & Crime.
I hate it when the get-out-of-free Donald Trump card doesn't work. It's such a shame when that doesn't work. But again, go to lawandcrime.com. You can learn a little bit more of the top trending stories of the day. But I want to talk about this NASCAR issue, and I want to bring back on Law and Crime trial analyst Misty Marris. Great to see you again, Misty. So here's my question to you about this. His blood alcohol level was twice over the legal limit. They're still investigating this. He's not been found guilty of anything. But if this really is all true, why does this happen? You would think a guy who's at that level wouldn't do this. He couldn't get an Uber. He couldn't get a limo.
Right. Oh, yeah, you're right, Jesse. I often wonder this because especially in the world we live in today, it's so easy. And Uber's a touch of a button, right? And so putting others' lives at risk, including your own life, simply is not worth it. And think about this. I mean, look, he's facing some thorny legal territory, but thank God no one was injured, no one was hurt, no one was killed. And to tell you the truth, and this is, we don't live far from here, as you and I were just talking about Long Island, there's been a crackdown on drunk driving in places where you don't have necessarily mass transit. So this is taken very seriously, and the purpose is to protect people's lives.
Right. This happened, I think, near the Hamptons at around 7:30 p.m. Prime time, people are eating, people are going to go out soon. That's a scary time to be doing this. Now, they held him overnight, they arraigned him in the morning, and then they released him on his own recognizance. What does that mean? Why did they do that?
So, released on your own recognizance, when the analysis that the court basically does is this person a flight risk? If a person's not a flight risk and they don't have other a criminal history, other issues in their past, from a criminal perspective, many times you'll see released on your own recognizance, which means it's essentially your responsibility to stay in town, stay close by. There might be limitations on your travel, but you're not a flight risk. You're not somebody who's going to grab a passport and hit the road and end up somewhere where you couldn't be extradited. Yeah,
and let's talk about NASCAR real quick. What are they going to do here? I know they're investigating the matter. Anybody going to speak to Trump about this? Really, legitimately, is President Trump going to have a tweet about this? Is he going to talk about it?
Well, look, I wouldn't be surprised. President Trump loves to tweet, and we know that he actually, in the past, he did have a relationship with NASCAR. He's said that before. Whether or not the president gets involved in this one, who knows? I would say there's probably some other more important stuff going on in the country,
Right.
but that's never stopped him before. But in this case, I think what we're going to see, and a lot of it depends on whether or not there's been a history of this type of behavior. If this is a first-time offense, even though he's twice the legal limit, and I think more problematic is the discovery of the oxycodone pills.
Right.
If that's all true, you probably will see a plea deal. And from NASCAR's perspective, look, private corporations, their analysis is, are you good for my business? And if we're going to lose money or there'll be something detrimental from a PR perspective, you might see them take an action against him.
And that's the struggle that they're going to have to come up with. It's not an easy situation, but we're going to cover it more. Thanks, Misty. I appreciate that. So we'll cover that more if there's an update related to that. Now, I want to switch gears and go back to the Stephen Foster case. This former Democratic congressional candidate, this former physician who was pulled over himself for DUI out in Georgia. Now, I want to play you the testimony of Adley Huertas Rivera from the GBI Crime Lab. She was one of the people that tested the blood. Remember, the blood's a huge issue in this case. The defendant wanted a blood test taken that night. His blood was drawn the night that he was pulled over, but it wasn't tested until sometime later. Let's learn what his blood alcohol content was from that test. Okay, so those results are not great for the defendant, but does it matter? Let's bring back in Misty. Misty, question for you. Have you seen cases, DUI cases, where if there's a discrepancy between the blood test and a field sobriety test or some other test, perhaps the defendant may have a good defense and not be found guilty?
Yeah, certainly, because all of those other visual factors that you talk about in a field sobriety test matter, and the jury is allowed to weigh them. So if there is evidence out there that would tend to show that somebody was not intoxicated, even in the face of a blood test, it's not like a situation where you've got no defense once that happens. What you do is exactly what's happening in this case. You undercut the results of that expert testimony or the sample and the blood test by talking about these other visual factors. And then it's just left to the jury to decide what do they believe is credible. Now, I've seen and handled cases where blood tests will get thrown out because of certain types of what we call chain of custody issues, meaning that they couldn't account for the sample. There's the possibility that something was tainted in that end result. So while they're not, the defense isn't raising necessarily an argument by utilizing expert testimony, that is essentially what they're saying in their defense of this case.
I mean, they're saying that by taking the sample and then freezing it, and there's an issue of fermentation, which could have affected the actual results, and that becomes an issue. We see this more when the defense cross-examined this witness. Let's play that for you right now. Okay, so this is a really interesting part, and I want you to imagine that you are a juror sitting on that jury. Is the defense poking enough holes into this blood sample testing that would change your perspective? Misty, what do you think? If you're sitting on that jury and you're listening to this, are they raising enough questions, enough doubt that makes me think, maybe the results of this test aren't accurate?
Well, I actually think that defense is doing a pretty good job, especially since we had such a long time period between the actual draw and the testing of the blood. So that goes to their favor. But I will say that from the perspective of where the defense has their best arguments, I think you're right, Jesse. I think it's those field sobriety tests and the fact that he wasn't, some of those objective factors just were not there.
Right. No smell of alcohol, not swerving. And you know what the best way to show that is? We are going to show you the dash cam footage of this entire arrest when we come back from our break, because what better evidence than to see it right there, how the defendant was acting and what he was saying. We'll take a quick break. We'll be right back. Stay tuned here on Law and Crime. So I'm going to be the first to say that I'm not entirely sure what he's talking about, but does it help his case or hurt his case? Let's go back to Misty. Says he's a weird guy, erratic personality, or is that someone who's drunk? Because I don't know what he's talking about. I think he's talking about maybe Hurricane Irma at one point. Then he's talking about a shotgun blast, a blind man who has a DUI. Do you understand what's going on here?
I got to tell you, I think he sounds like an intoxicated person. And I'm not sure that that video helped him in any way. Now, of course, the prosecutors want you to see that, right? Because if you're leaning towards some of the arguments that we spoke about before, I'm not sure you can explain away that type of behavior, being pretty aggressive with the police officers by saying of the ADHD and malaria and all this other stuff. I'm not sure that really cuts it.
Yeah, and we can't forget the fact that that wasn't even his wife in the car. It was, we don't know who she is. So there's a lot of weird facts in this case, and we're going to talk more about it after this short break. But I do have to sign off Misty. Misty, thank you so much for coming on this morning. You've been great.
Thanks, Jesse. Always a pleasure.
Misty Marris, Law and Crime trial analyst, everybody. All right, here on our end, what we're going to do is we're going to take a break, but when we come back, we're going to play the testimony of Detective John Edwards from the Dalton Police Department, and we'll learn a little bit more about this bizarre tale of this congressional candidate getting into trouble. We'll be right back.